Section 7. When accused is lawfully arrested without warrant, a warrant was involving is offense which require a preliminary investigation. The complaint or information be filed by a prosecutor without needs of such investigation, provided an inquest has been conducted in accordance with existing rules. In the absence or inability of an inquest prosecutor, the complaint to be filed by the offended party of a peace officer directly with the proper court on the basis of the affidavit of the offended party or arresting officer or person. Before the complaint or information is filed, the person arrested may ask a preliminary investigation in accordance with this rule that he must sign a waiver of the provision of Article 125 of the Revised Penal Code as amended, and the presence of this counsel, notwithstanding the waiver, he may apply for the bail, and the investigation must be terminated without 15 days from the exception. After the filing of the complaint or information in court without a preliminary investigation, the accused narrated 5 days from the time he learned of its filing. As a preliminary investigation with the same rate evidence and defense as provided in this rule. Section 8. Records. A record supporting the information or complaint. An information or complaint filed in court serving supported by a affidavit and counter affidavit of the parties under the witnesses together with the other supporting evidence and the resolution of the case. B. Record of a preliminary investigation. The record of the preliminary investigation, whether conducted by a judge or a prosecutor, shall not form part of the record of the case. However, the court of its own initiative or on motion of any party may order the production of the record of or any of its part when necessary in the resolution of the case, or any incident wherein it is to be introduced as an evidence in the case by the requesting party. Section 9. Cases not requiring a preliminary investigation are covered by the rule of the summary procedure. A. If filed with the prosecutor at the complaint is filed directly with the prosecutor involving an offense punishable by imprisonment of less than 4 years, 2 months, and 1 day. The procedure outlined in Section 3 of this rule shall be observed. The prosecutor shall act on the compliant with the affidavit and other supporting documents submitted by the compliant without 10 days from its filing. B. It's filed with the municipal trial courts. If the municipal trial courts or information is filed when the municipal trial courts or municipal circuit trial courts or an offense covered by this section, the procedure and if the 10 days after the filing the complaint and information that the judge found as probable cause, the personal evaluating and the examining and writing and under the compliant and his witnesses in the form and searching questions and answer, he shall be dismissed the same. However, the submission of the additional evidence within 10 days from notice to determine whether the existence of probable cause at the judge still finds no probable cause despite the additional evidence, he shall witness 10 days from its submission or expiration of said period. Dismiss the case, and if finds probable cause, he shall issue a warrant of arrest or a commitment order if the accused is already been arrested and heard him for a trial. However, if the judge is satisfied that there is no necessity for placing the accused under custody, he may issue a summons instead of a warrant of arrest.